Welcome to Law Family. This video is helpful to the law students and newly practicing young advocates. Today, we discuss about the sections 2 HLB of BSA Act 2023. Corresponding law section is section 4 of Indian Evidence Act, may presume, shall presume, and conclusive proof. Every practicing advocate must understand how to use the presumptions in evidential procedure in courts. That is, understanding when presumption applies in critical part of courtroom strategy and procedure. These three principles are the cornerstones of the judicial procedure. The word proof means such evidence as it would induce a reasonable person to come to a particular conclusion. It was further observed that a presumption is an inference of a certain fact drawn from other proved facts. The courts applying a legal process of intelligent reasoning which the mind of a prudent person would do under similar circumstances. A presumption is not the final conclusion to be drawn from other facts, but it could as well be final if it remains undisturbed later. Again, it is the key and important point. It could as well be final if it remains undisturbed later. Presumption in the law of evidence is a rule indicating the stage of shifting the burden of proof from a certain fact or facts. The court can draw an inference, and that would remain until such inference is either disproved or dispelled. It was held that for the purpose of reaching one conclusion, the court can rely on a factual presumption. Unless the presumption is disproved or dispelled or rebutted, the court can treat the presumption as tantamounting to proof. However, courts sounded a note of caution by stating that it may be unsafe to use that presumption to draw yet another discriminatory presumption unless there is a statutory compulsion. A presumption can be drawn only from facts by a process of probable and logical reasoning and not from other presumptions.
Welcome. The cases in which secondary evidence relating to documents may be given are stated in section 60 of BSA Act. Corresponding law section is 65 of Evidence Act, and also read with section 64, 65, 66 and 77 of BSA Act 2023. Corresponding law sections 66, 67 to section 78 Indian Evidence Act. Proof of documents, whether public or private, including execution of such documents, etc. Presumptions. Courts are authorized to draw a particular inference from a particular fact unless and until the truth of such inference is disproved by other facts. Courts can, under Section 2H of BSA Act, corresponding law Section 4 of Evidence Act, raise a presumption for purpose of proof of a fact. It is well settled that a presumption is not in itself evidence but only makes a prima facie case for a party for whose benefit it exists. It is well settled again. It is well settled that a presumption is not in itself evidence but only makes a prima facie case for a party for whose benefit it exists.
There are three categories of presumptions: presumptions of fact or natural presumption. Second one is presumption of law, that is, rebuttable presumption and irrebuttable presumption. Third one is mixed presumptions, that is, presumptions of mixed law and fact, or presumptions of fact recognized by law. The expression may presume and shall presume in Section 2HL of BSA Act, corresponding law section of Evidence Act, corresponding law section 4 of Evidence Act, are also categories of presumptions. Most important point: factual presumptions or discretionary presumptions come under the division of may presume, while legal presumptions or compulsory presumptions come under the division of shall presume. May presume that it leaves it to the discretion of the court to make the presumption according to the circumstances of the case, but shall presume leaves no option with the court, and it is bound to presume the fact as proved until evidence is given to disprove it. The expression shall presume is found in sections 78, 79, 80, 82, 84, 91, and 108 of BSA Act 2023. Corresponding law section is 79, 80, 81, 83, 85, 89, and 105 of Indian Evidence Act. Proof of the fact depends upon the degree of probability of it having existed. Here is the important point. This one is the very important point. Proof of the fact depends upon the degree of the probability of it having existed. The standard required for reaching the supposition is that of a prudent person acting in any important matter concerning him.
May presume, shall presume, and conclusive proof is also used in Section 2HLB of BSA Act 2023. Corresponding law section is 4 of Indian Evidence Act. When the law says that a particular kind of evidence would be conclusive, that fact can be proved either by that evidence or by some other evidence that the court permits or requires. Once again, when the law says that a particular kind of evidence would be conclusive, that fact can be proved either by that evidence or by some other evidence that the court permits or requires. When evidence which is made conclusive is adduced, the court has no option but to hold that the facts exist. Conclusive proof gives an artificial probative probative effect by the law to certain facts. No evidence is allowed to be produced with a view to combat that effect. When a statute makes certain facts final and conclusive evidence to disprove such facts is not to be allowed. Thank you.
Thank you.